Good afternoon, everyone. As Dean of the College of Law, it is my distinct pleasure to introduce our speaker today, the holder of the 2013-14 Law Foundation of Saskatchewan Chair, Professor John Wade. However, before I do that, I would like to say a few words about the Law Foundation of Saskatchewan and the history of the chair. Those of you who attended the College of Law update that I delivered at the CBA midwinter meeting in Regina last week know that I mentioned the Law Foundation in my speech and the generous support given by that organization for a number of our programs, including our mooting programs, Classic, and our graduate program. The Law Foundation itself was established in 1971. Its funding is derived from the interest generated by lawyers' trust accounts in this province. The Foundation's mandate is to maintain a fund to be used for the purposes of legal education, legal research, legal aid, law libraries, and law reform. The Foundation accepts applications for grants that fall within these purposes. And as I have said, the law school has been and continues to be the beneficiary of much of this funding. And we are truly grateful for that. In 1989, the Law Foundation donated $800,000 to establish the Law Foundation of Saskatchewan Professorship Fund. Immediately, this endowed fund was enhanced by the infusion of an additional $400,000 from the University of Saskatchewan. As a result, the Law Foundation of Saskatchewan Chair was born. The terms of reference for the chair stipulate that the, quote, incumbent of the chair will be an accomplished legal scholar or an outstanding person with a background in law and a demonstrated interest in scholarly investigation and practice relating to issues in law and legal policy. Past holders of the chair include the former Premier of Saskatchewan, Alan Blakeney, and noted academics such as John White, Denise Reume, and Judith Fudge, to name but a few. I believe that the College of Law is the only law school in Western Canada to have a visiting professor chair of this nature, and we are extremely fortunate to be in this position. The chair allows for the exchange of ideas between our law school and those of the visiting professors. It exposes our students to leading national and international legal scholars and teachers. And at a time when there are significant pressures on law school faculty complement, it provides a welcome augmentation of our professorial numbers. But you didn't come here to hear me speak. The main attraction, as it should be, is Professor John Wade. John is Professor Emeritus at Bond University in Australia and a distinguished practicing lawyer. He is nationally and internationally acclaimed as an expert in dispute resolution, legal education, and family law. For the past 40 years, he has taught at 2 Australian, 3 Canadian, 1 French, and 4 American law schools. He has led over 250 courses in mediation and negotiation for law firms, government, and industry in the United Kingdom, Hong Kong, New Zealand, the US, Indonesia, Australia, and by virtue of the fine workshops he's put on here in Saskatoon during the tenure of his chair, Canada as well. John was one of the founding editors of the Legal Education Review, and he pioneered the postgraduate teaching of educational methods and theory to new law teachers. He has published over 100 books and refereed journal articles. Since 1987, John has mediated hundreds of disputes in areas of family property, organizational succession, insurance, and child disputes. He has developed a specialty in family property conflicts. In 2011, John was named by the International Bar Association as one of the top 9 commercial mediators in Australia. Today, Professor Wade will be delivering the 2014 Law Foundation of Saskatchewan lecture, which is provocatively entitled, Negotiating with Difficult People. Without further ado, please join me in welcoming Professor John Wade, the 2013-14 Law Foundation of Saskatchewan Chair.
Thanks very much, Sanj. I'll take you through a paper which will be available on some kind of website so that people can follow through. It's just called Negotiating with Difficult People. This is drawn from practical experiences as working as a lawyer in negotiation and also working as a mediator. So as a pracademic, one tries to take the experiences of life and work back to theory and ask, what does theory say about the very difficult client we just dealt with, the client from hell, as the practitioners say? Are there any principles to be extracted from that either good or traumatic experience you went through? So what I'll do is I'll take you through this. It suggests a working definition of a difficult person, and then describes some of the outward behaviours of a difficult person, and sets out 5 overlapping causes of why people are particularly difficult, and then some possible responses, both from practice and then what does theory say about that. So there's a cartoon thrown in occasionally to keep you awake. But let's try and work on a working description of difficult. We all negotiate each day in what we do, and we find difficulties in negotiation because someone talks more than us, we talk less. Someone beats around the bush, we go straight to the point. Someone tries to ambush us with new information and we weren't ready for that information. Some people are very emotional and we are much more rational, being law students. Some people are very organised and we're disorganised. So there's always difficulties because people are different to us. So you could start off with a working definition. Anybody who's different to me is a difficult person. But that would catch too many people. And so I'm going to try and narrow it right down to a working definition of a difficult person is somebody who appears to be acting against their self-interest. So when you're negotiating with them, they seem to be behaving in ways that are detrimental to their corporation, to them being re-employed in that organisation. They are either detrimental to themselves or to their own organisation. So they swear a lot during the course of negotiations in a culture where swearing is not appropriate. They ambush you with a huge report as you walk into a negotiation and think that's very clever. They come to negotiations with no perception that other people may be interested and have goals in their lives. They're totally obsessed with self. I, me, mine. You look at them during a mediation or you look at them during a negotiation and say to yourself, and maybe even to them, as what are your life goals? Are you actually engaged in a self-destructive process here? So like all working definitions, it is over-inclusive because many of the heroes of our culture, at the time they were negotiating, whether it be Gandhi or Wilberforce or Solzhenitsyn or Jesus, they were considered to be problematic people. They were engaged in self-destruction, they were engaged in destruction of some of the people around them. So, like all definitions, it wobbles, but we've got to have something to work from. Lawyers too are sometimes called difficult people, not just in the sense that we are aggressive or articulate, but sometimes you'll find in negotiations lawyers described as, he's the problem, she's out of control. Various shorthand phrases. I'm very interested in studying the shorthand phrases of cultures because they hide a lot of marvellous things to research and to study. I would guess from my life experience about 30% of the clients I deal with are difficult in that sense. They appear to me, as the outside observer, to be engaged in a kind of self-destruction. There's a very important form of law called law of the law office, and it's difficult to study law of the law office, but one classic study in 1986 looked at what lawyers say to clients behind their closed doors. And this is how the conversation goes in family. This is one of the few pieces of research in the world on this, which I related to so strongly, is the lawyer says to the client, this is how the system works, and the client says, oh, but that's not fair. And the lawyer says, but let me tell you that the judges are basically incompetent, the system is delayed, it's highly expensive. Oh, but that's not fair. Yes, but this is how the system works. Oh, but that's not fair. Yes, but that's how the system works. So I'm describing your life, those of you who are going to be lawyers. The yes, but, oh, but conversation. How long does it last on average? 2 years. For 2 years, you're engaged in attempting to educate your client about the vagaries of the system, that the system is irrational and it's out of control. Are those difficult clients or are they normal clients? I think they're probably normal clients. They're not clients who are engaged in self-destruction. They just have to be educated about the system. So it's not someone who's different to me, but it's someone who appears to be behaving in ways detrimental to their own interests. I narrow the definition twice more for you, in that the Latin root of the word negotiate, it in fact means stress, out of control. So the ancients were wiser than us, yet again. The normal meaning of negotiation is I feel a sense of stress and loss of control. So we're not talking about normal negotiations. There are negotiations going on in this university at the moment, and those will often seem to you to be out of control, but they are normal. Likewise, you sometimes meet clients who, in the language of observers, stonewall. These may be clients who you're working for who say, John, I don't care what the result is, we're going to give this insurance company hell. I don't care what the outcome of this union negotiation is, we're going to make sure that the employers suffer and suffer publicly. It's a matter of revenge and a matter of indicating to them that they need to suffer as I am. So the BC teachers and the BC government are at the moment going through one of those negotiations. And those are not irrational negotiations, rather the person is stonewalling for a reason, to ridicule the other side, to give my life meaning, because I hate men, women, doctors, lawyers, whatever it might be. So we're not talking about rational stubbornness, we're talking about actual apparent self-destruction. Right. Perhaps those people need a judge, perhaps they don't, because often when you get a judgment it's not enforceable in any case, and the judgment sits there as a piece of paper and the people continue their crusade. So this is an Australian cartoonist who's very profound in his name's Lunig, in his insights into the human condition. I really like this one. Okay, what are the causes of being especially difficult in the self-destructive sense? And I've moved them back into categories, 7 habits of highly effective people. We can either go on a black box theory that human condition is mysterious, that we can't define it, or we can attempt to put things in categories. The 10 reasons why marriages are successful. Here we have the 5 reasons of being especially difficult. Of course, 5 is artificial. It's more like 105, but human beings, we can't cope with 105 reasons, so we reduce them. So habit and culture. And we'll start on that. So a number of lawyers I know are accused of being very difficult people because they're caught in the habit of 35 years habit of going down every rabbit hole, of what the Americans call churning the file, and looking at every possible angle, incurring large expenses, and then settling at the door of the court, is often damaging to their clients, to their corporations, to the individuals they're acting for, but they're stuck in that habit. It may be a self-protective habit that they go down every rabbit hole, search out every point, but they say, this is how it's done in Jakarta, this is how it's done in Melbourne, this is how it's done in Toronto. Some clients talk endlessly about justice and fairness and righteousness, and they're stuck in that talk. That's their habit. One of the partners I worked for many years, she would slam her fist into the desk and look at the client and say, we don't sell justice here. Don't ever mention that word again. And she was a quiet kind of person, but she had this nice tantrum routine which taught people, don't use the justice word. All we can give to you is a satisfactory commercial outcome. We can work through it like a jigsaw, and that's what we do here. We're very good at it, but we don't sell justice and we don't sell fairness. We understand market price going rate. So habits are ingrained, and attached to them you have culture. Culture, in this paper that you can have a look at later, culture necessarily stereotypes. You can't study culture without stereotyping. You can't study every individual in Saskatchewan society. You have to generalize about bankers, middle class, middle upper class bankers in Hong Kong. So the stereotypes are well researched. Americans are always in a hurry. Japanese never get to the point. Norwegians send juniors to negotiate, so I do a lot of work with Norwegians and Swedes, and they drive other people crazy because of their flat culture. They will send young females to negotiate multi-million-dollar contracts when they're dressed in jeans. And so when they negotiate with French or with Chinese particularly, the negotiations are over as they walk in the door, because it is so offensive to have a young female with authority to settle, especially when she's wearing what's classified as informal clothes in cultures which only want elders who can never settle on the spot, who must always go back to their tribal groups, go back to their constituents. So you can, Australians are laid back and disrespectful, and you can fill in the gap. Canadians are? Polite. Late, polite, or late? Both, okay.
But if they're late, they're always polite about it.
Yeah, if they're late, they're always polite. So Canadians are? Canadians are. So Canadians will do very badly in Russia and in France because it's appropriate to stand close to people and yell and tell them they're wrong, tell them they're stupid. And as Canadians will find that quite difficult to how do I respond when a Russian throws a tantrum and throws something at me and walks out. So sometimes culture leads to someone being particularly difficult. You ask, why did they destroy the negotiations by having a tantrum? Answer, because tantrums are normal. So I have a number of Russian students I work with, and they say, well, we have tantrums when we're upset, and then we walk out. And I say, this is a really problem for us, is how do you get back in the room? They look at you as though you're weird. They say, I walk back in the room. But isn't there a loss of face to have had a tantrum and walked out? No, they don't even know what you're saying. So likewise, in France, if you come in and start talking about your children before a negotiation, the negotiation's probably over, because private life and public life is separated, whereas in Japan, it's essential that you talk about your private life, and you have photographs, and you discuss these things, absolutely essential. So in the paper, it's got a series on pages 7 to 8, when you get hold of this paper. It's got a series of classic cross-cultural clashes. For example, again in France, if you don't interrupt in France, you're considered to be a fool. Whereas Canadians like you not to interrupt. And Norwegians, if you interrupt, the negotiation is definitely over. All right, so how do you deal with this in terms of responses? It's often helpful, though it may be seen as a negotiation weakness, to admit, I'm new to Jakarta, I'm new to Vancouver, I'm new to Sydney. Could you help me with how we should run this negotiation, to actually admit the cultural ignorance? It's worth studying offensive triggers. So to be late in Norway or Switzerland, that means the negotiation's over. To begin a negotiation in Japan with, well, we've all made a lot of mistakes, it's time to get down to business here and work on the future, the negotiation's over. You've publicly stated, we've all made a lot of mistakes. You don't know it's over, but it is over. So study the offensive triggers. Bring a respected advisor and weld them to your hip and ask them to give you guidance, and that will be, those are the responses I think that will give you a beginning working response. There's a huge amount of literature on this, of course. This is one of the trendy topics in business school, communication school, international school, and law schools now, is cross-cultural negotiation, and how to avoid giving accidental offense when you don't even realize that you're giving it. So another cartoon, another test there for you. Very relevant to lawyers, that one. Next, a close cousin of habit and culture is high emotion. And so people who work in employment law, family law, succession law, and business takeovers are well aware of emotion getting, in our Western sense, out of control. It seems that the emotional side of the brain begins to trump the rational completely, and commercial goals go down the drain. Tort lawyers likewise see this. So it's not only the emotions of the client, the person up front, but behind every client there's a tribal group. Could be the board of shareholders, could be the father-in-law, and the tribal groups are divided into hawks, doves, and moderates, each tribal group. So you're negotiating with the visible people, and then the tribal group in the background who may be highly emotional, saying, we have to teach these people a lesson, we have to make sure that they never do this again. So how do lawyers respond when dealing with a client who won't focus on their own life goals, their own commercial goals, but they seem to be either depressed or very angry, out of control? And one of the lawyers I used to work with, and when I was a very young lawyer, one of his strategies was that of masterly procrastination. And so I came to call it the lose the file tactic. So when an emotional client gave him instructions which he didn't agree with, which he thought these were going to be regretted by the client, he would lose the file. So the client would phone up and say, Peter, have you drafted that agreement yet? Oh, I'm very sorry, we're having trouble finding your file. But don't worry, we've got some people looking for it. I'll get back to you when we find it. In other words, when he got the wrong instructions from the client, he'd lose the file. And so then eventually the client would go through the Kubler-Ross stages of grieving and come out the other side and say, well, I've rethought the settlement, we really should be doing X and Y. Peter would say, good news, we've found the file. They didn't teach you that in the ethics class, did they? There's all kinds of things that go on which are a way of helping clients, but they're dangerous when you do that. And as you know from that study I mentioned to you, to the extent that researchers have been able to get inside lawyers' offices, the most popular method of managing conflict for lawyers is to talk, tell stories to their clients. Talk. I once had a client. We once had a situation. Last week this occurred. You need to think about this. The yes but, oh but conversation in an attempt by the blah blah, by the trustworthiness, by the friendship to take people through their grieving to maybe a stage where they give more realistic instructions rather than self-destructive instructions. So you have a long list of possible responses to high emotion. A shopping list. There are some of them. The one that you need to have these all in your repertoire, like a good basketball player or tennis player. You need a lot of shots in your repertoire and work out which are your favorites. So 10 is often used. Be very careful of 9. 9 is going to get you into professional negligence troubles. Don't worry, leave all your troubles with me. I am famous, I will help you through this. Give that one up, okay? Know that it exists, but abandon that. It's called the white knight strategy. Don't take that up. Some older practitioners still do that and cause law societies and the insurers a lot of nervousness. Number 11 is very popular. I can see you're very distressed. I can see this has been a terrible experience. You've been through the valley of the shadow and so on. However, my skills, my role is to help you concentrate on X. Let's concentrate on X. Are you able to do this? I use, as you'll see, number 13, I use a lot, which also for you in law school, you might find, oh, but they're not my client. How can I have a relationship with a trusted friend? What sort of agreements do we sign up? So a lot of the technical questions people ask are just glossed over in practice, and people troubleshoot for solutions. Unless there's big dollars involved, then you sign up everybody. So a lot of these solutions need to be in your repertoire. Okay, next, the inappropriate strategy. Right, strategy is a behavior that you choose to give you an advantage and to put the other person at a disadvantage, something that will discomfort them. And some people adopt strategies which may have worked in a few cases, but they become their tools of trade. So they scream, it's a lot of effing during the time that you're negotiating. They send emails which are extremely inflammatory in a large organisation, and then wonder why all hell breaks loose. They drown other people in in data. They bring along huge reports. They send them several thousand pages of documents, thinking they're being smart and clever, thinking that they will wear out the other side. They do what we call add-ons. Just as you're about to get a deal, they put up there, John, there's one more thing. So this is the one more thing strategy. And they're really continuing the negotiation because they have a sense of loss. It's called negative intimacy. They're intimate with the conflict, and if it ends, their life has no meaning. So there's always one more thing. So what do you do? Oh, I wrote a note here in my papers. I give them the example of Charles. So Charles is a lawyer that I've worked with for many years, and Charles is a genius. His photographic memory, and he has major personality disorders. So Charles has a disorder that during the course of a negotiation, if one of the clients on the other side says to him, Charles, why the hell did you send that inflammatory email? So he makes a statement, because Charles sends a lot of inflammatory emails. And that is a huge mistake, because Charles takes that kind of sentence as an insult and immediately attacks the client. And he's far smarter than anybody in the room. So the client is reduced to a blubbering wreck. And Charles holds on to that grievance for maybe 6 months or a year. And he speaks of it as, oh, that effing client. And then he's surprised when the whole thing goes to hell. He says, well, they didn't settle, John. It was amazing. I made them an offer and they did. He can't understand what is going on when he has been so insulting towards a client or a lawyer. So when I did a lot of mediations with him, and I had to learn how to manage Charles, and these were the two methods used, because he couldn't self-perceive what he was doing. I would say to the clients on the other side, never, ever argue with Charles. This is the sentence you must use. You must say, Charles, I disagree. You must use the word disagree with the content of your email. You must never say it was an inflammatory email, it was a stupid email. And the clients fight with me and say, John, I'm not going to be told what to do. I'm not going to be told what sentence structure to use. I say, well, when you're negotiating with Adolf Hitler, you need to know about sentence structure. You need to know about sentence structure because there'll be a long-term price. He will destroy his own client and you if you create a grievance. And then the other great thing I discovered too, later in the career is that Charles changed his personality in his own law office. He is a most gracious host in his own law office. He serves wonderful coffee and sandwiches. And so I would always phone him and say, Charles, could we meet at your office? Why is that, John? Oh, because you serve such great coffee. But he changed personality. He was gracious to people, and even when they were semi-insulting to him, it was like water off a duck's back. Take him out of his office, he was back to monster mode, and his strategy was to attack with very strong language and highly skilled reasoning. Had a photographic memory, and he was not a good person to cross on any factual issue. So, how do you deal with inappropriate? What is a strategy? Is a consciously chosen behaviour, as compared to a habit which may be more subconscious. Okay. There are 4 classical responses. I'd like you to practice these in the mirror for the rest of your life. This is the rest of your life that you're seeing now, because you will meet many people using what you classify as inappropriate strategies. They seem to be self-destructive or destructive of the negotiation. First one is like a toddler having a tantrum. Learn how to ignore what's going on, just as though it... So can we discuss the numbers here? Can we discuss what the business would look like in 3 years' time? The other person is playing good cop, bad cop, or is playing tantrum or is swearing in a culturally inappropriate way. So some lawyers have modified versions of ignore that they say, I'm going to pretend I didn't hear what you just said, Charles. It's a very powerful statement. I'm going to pretend I didn't hear what you just said. Or, more obliquely, my hearing is very bad today. I've forgotten to take my pills. All kinds of code messages which are saying, I'm really not going to listen to that. Another version of that which I've seen is, John, did you find that number in a telephone directory? It's nice, isn't it? It's nice. It's just saying a lot. Don't have to say much more. Next, you need in your repertoire to practice labeling the behaviour. Now, this is sometimes difficult for Canadians because they say it's offensive, but it's a very important. You can label behaviour gently. You need to learn how to do this gently and harshly. So both versions. So label the behaviour. For example, John, could I talk to you outside for a moment? John, it seems to me that since we've arrived here today, you'd be playing good cop, bad cop. You're smiling, you're being very gracious, and you brought along Mary, and Mary is effing this and effing that and growling. And I was wondering what you want us to do about that. Label and ask, what would you want us to do about it? Label the process, what should we do about it? Very important routine, or you can do it publicly, which may involve more lost space. Next, take a break, which is very important when you see strategies occurring. Oh, we just need to take a break, we need to have a cup of coffee. And in that coffee say, what the heck's going on? It looks like the good cop, bad cop routine. It looks like the humiliate the weaker person routine. What should we do? And occasionally use emphasize theatric strategic responses. Now this is dangerous because it's so emotionally gratifying to scream at other people. But you should avoid this emotional gratification. It must be theatric, not reactive. Theatric reaction. So you can go outside and plan to have strategic loss of documents, strategic screaming, all kinds of things. Bring along a bad cop. Practice those 4 things for the rest of your life. Very, very important. More cartoons. Okay, next is illness. So illness is a very important topic in modern industrialized societies and very important anywhere. It's difficult to define the distinction between health and illness, between deviance and genius. So where is the line that says this is illness? So you once again could put it all in the black box and say this is too hard, John. Just so you know, in Australia there's much more research on depression within the legal profession than I see here. And every 5th solicitor you meet will be suffering from chronic depression in Australia. Okay, every 5th solicitor. If you go to the bar, that's people who appear in court more often, then the numbers just soar because they increase with cocaine use in the bar. Is people getting themselves up for the strong performance and then down after the strong performance. So illness within the legal profession is a major topic. That means every 5th lawyer minimum that you negotiate with will be flat, a bit irrational, not responding when you raise a particular topic. So that changes your whole thought pattern as to how I should be dealing with my colleagues within the profession. So illness is also used as an excuse. The devil made me do it, not my fault. Illness is used as a way of discounting people we don't like, people who are particularly insightful. We call them psychiatrically ill. It's an old device used in many dictatorships too. So you could probably say, though, that there is an increasing visibility of illness, mental illness in your clients and in the profession. May have always been there. And so how to manage that? This is particularly driving the judiciary crazy because when you ask the judiciary in most societies what is the major problem they are dealing with, self-represented clients who are out of control. They use euphemisms, but they also say sometimes these people appear to me to have major personality disorders, or sometimes they appear so distressed that they can't control what is appropriate in their lives. So this is a tough one. When you come across this and you suspect this is the reason for the self-destructive behaviour, what can you do? Responses. Okay, so these are the responses. This is the pracademic. This is what I did in practice. I refused to negotiate until my client gave me permission, if I suspect my client was going through the valley of the shadow, to have access to all their reports, medical reports, and for me, they had to sign off to speak directly to their doctor or to their psychologist. And I would refuse to act for them until I had that access, and so the psychologist or the doctor would feel comfortable talking to me. And then the more difficult one is vice versa, to say to the other side, I refuse to work with you until we have an independent report done and confidentiality is not a topic. This person can report back to us, this psychologist or this doctor. Next, one I've used a lot is the wise friend. I'm not prepared to negotiate for you unless you bring along a wise friend, because this is going to be a tough meeting, there's going to be a lot of tension, got to be hard decisions. And likewise, to say the other side, is there a wise friend that Bill or David or Mary can bring along, because this is going to be a tough meeting, there's going to be hard decisions to be made. And then must be permission to talk to the wise friend beforehand. Once again, these confidentiality issues that can tie up lawyers, you have to free up to say, I can talk to the wise friend to say why we're asking them to come along, how we expect them to be helpful, if they can be helpful, and then always warn them, you may not be the wise friend at the end of this negotiation. Wise friends are generally turned upon at the end of tough negotiations, right? So they have to be aware of the price of being a helper in this case. Accountants are fantastic wise friends, better problem solvers in my experience than many other disciplines. They think in numbers. I found accountants to be great, but also family members, next door neighbours in some situations. And then finally set up the environment so that the environment is conducive to comfort. People are comfortable, stay longer, talk more. So I've done negotiations where we've set up the meeting next to a motel, so one of the parties could go and have naps on a regular occasion and then come back into the meeting room. I've done negotiations with a fellow with a major personality disorder, and he's also a marijuana addict, and so we would stop the negotiation regularly, became way too regular, and we'd send him downstairs to smoke up. And then we'd come back upstairs and we'd keep going, because there was no other way to hang on to this guy who was on a very self-destructive track. He was an American living in the sunshine of Australia, and he had lost the plot altogether. And then the other one, which lawyers like, say, oh, this is out of control. I must refer this client elsewhere to somebody else. And so this is called send them to the wilderness in Australia. Because if someone else is a judge, judges are not willing to flick past these kinds of cases. They flick past them back to the lawyers and say, John, go outside and settle this. Mr. Wade, go and fix it. Or they say, I'll send it back to a mediation. So judges are not willing to be the last stopping point for the massive numbers of mentally ill in society. So be careful of using that. I will refer it elsewhere to fix. Next, decision traps. This is a great topic. Some of you have done this before. A fifth reason why people seem to be crazy, why we invade Iraq. Decision traps. This is what you study in Psych 101. And what's happened in Psych 101 is that learning has slowly filtered across to law schools in about the last decade. And this is wonderful stuff to study. It's very insightful, and psychologists just shake their heads and say, where have you lawyers been for the last 100 years? But when we do these modules in law firms, the partners of the law firm say, oh, this is so helpful. I wish, here's the statement, I wish I'd known about this 30 years ago. And my experience of dealing with lawyers is that they do know this. They don't read books. They do know this. And so here are some of the great phrases you hear from lawyers. Can everyone write them down, practice them? These are the lines to Macbeth and Hamlet that you must have in your repertoire. So these are the lines. Lawyers say, on my understanding, on my current understanding. They say, correct me if I'm wrong. So there is this great humility about self-knowledge. I don't know much. I'm just a person doing the best I can in this job. They have other great phrases. Only fools rush in. Presumptions make fools of all of us, John. It's one of my first lawyers who would look at me. Presumptions make fools of all of us. Don't pretend to know what other people are thinking. We don't know what we're thinking. How do we know what other people are thinking? Or on what evidence do you base that statement? And that's the harder question, a great question. Or the lawyers, I've been wrong many times before, so I could be wrong now. Say to the clients, I've been wrong many times before. You only have to have traumatic experiences in litigation about 4 or 5 times when you start to see that you do not understand the system or how other people think. So what's a decision trap? A decision trap, they're known as cognitive heuristics, horrible phrase. A decision trap is a shorthand rule of thumb which assists us to make decisions in a complex world. So as human beings, and we're wired to use these because we can't go back to Plato and Aristotle and start from first principle on each decision, we have to have a shortcut. And so we use the shortcuts to help us make decisions in lives. And the shortcuts are very helpful sometimes and devastatingly unhelpful in others. So I'll take you through a few of them, and I really encourage you to read some of the literature on this. It's fun to read, and there are many uh-oh moments where you say, uh-oh, I do that all the time. So here's a classic one. And can I emphasize to you, lawyers think we're immune from these because we went to law school, right? We're very rational, highly intelligent. We're beyond mere psychological theories. Wrong, wrong, wrong. All the research says that lawyers think they're not subject to these, and guess what? And they are. The research confirms this double message. All right, anchoring. Human beings tend to over-rely on the first image they get, the first impression. So therefore, speak first in negotiations. The person who speaks first has a huge advantage. They are creating a set of images. Next, the person who offers the first price, the sticker price on the motor car, has an advantage because that anchors people. Next, sunk cost, you know all about this. Human beings are wired, our brains are wired to protect earlier decisions. I've decided to be a lawyer, therefore I'm going to be. I've decided to commence litigation, therefore I'll continue it. It's called entrapment. The most famous example of this, or one of the most famous, was Lyndon Johnson during the Vietnam War. He says, we have lost 54,000 boys. We can't leave now. Right? You hear this in litigation all the time, but we've spent $167,000. We can't give up now. What's the right response to that? Just over 90% of cases settle. In any jurisdiction, some jurisdictions it's 99% of cases settle. So the answer is, what's the number when you will withdraw? Give me the number. And with Lyndon Johnson it was 58,000 boys, 4,000 more. And then he got out. Mythical fixed pie beliefs. This is the standard statement over the phone. John, this is just about money. Every dollar I give, they get, and vice versa. Wrong, wrong. Never had a negotiation ever that I've been involved with that's just about cutting the pie. There are other things going on. Status quo, also attached to sunk costs, is we tend to keep on with what we've done. We're very comfortable with the status quo. It's very difficult to get people to change, as all change managers know. We feel comfortable with the way we teach, with the way we practice law, with the way we raise children. Confirming evidence, we see what we want to see. Human beings are wired to see what they want to see. I once had a bad experience in Queensland where I was involved in litigation, went to a Court of Appeal decision, watching the 3 judges, long arguments before them, and I'm sitting there saying, we've lost that judge, but we've got the other 2. I saw what I want to see in the questions they were asking to the counsel. I think we've got the other 2. So we're going to be successful in this appeal 2-1. 2 months later, the judgment comes out, 3-zip. 3-zip. I saw what I wanted to see in the way they cross-examine counsel. Likewise in mediations, I often get people say, John, they're ridiculing us. See them over there, they're smiling, they're laughing. And I say, could they be laughing at a joke? No, they're laughing at us. John, they're stonewalling us. They didn't answer the email. They're trying to wear us down. I wonder if they were on holidays. No. They're trying to wear us down. Framing trap, very important. You do a little bit of this at law school, and when you spot issues, you issue spot in a torts exam, in a contracts exam, in a criminal law exam. You frame a question, but human beings are wired to draft the wrong question. We're wired to draft the wrong question. So you learn a certain set of skills devising legal issues, but in problem solving, in business problem solving, you need another set of questions, and it's a high skill to frame those questions. Now this one is very important, everyone. Whenever you go to negotiation, always take along a one-page document, if possible with a pie chart, if possible in colours. Human beings are overly impressed by one-page documents. And when someone gives you a one-page document, you need to know what's going on too. This is overly impressive. However, the response is, thank you very much for this beautiful document. I really like the multicoloured chart you've got here, John. But I think it's more complicated than the chart. That's the response, okay? You need to practice that in your Macbeth and Hamlet speeches. But it's very important to be able to give executive summaries of everything down to one page, and you are powerful beyond what you should be. Winner's curse, you know human beings are wired to have regrets. Post-settlement blues, we cut a deal and the client turns on you and says, you could have done much better, or I could have done much better. Overconfidence, this particular decision trap is encouraged by law school, where we're encouraged to be confident, but it's already in our wiring. We're very sure of our ability, very sure of our analytical skills, when life is much more complicated than analytical skills. Base rate trap. Humans love statistics, what is normal, what is the going rate, and we use false statistics. So I'm giving a class tomorrow which has a classic example of that. In Australia, the question is, how often do judges make orders that parents have equal time with children? How often in a contested case they make orders? And the literature is out everywhere. False base rate. The judges are increasing the numbers of contested orders they're making for equal time for children. They're increasing. So I thought, I've never seen a judge give an order for that. I'll go back and have a look. Went back to the stats. 2007, how many such orders were given? 0 in contested cases. 30,000 separating families with kids. About 300 contested cases, 0. 2008, 4. Now, is that 4 out of 300 or 4 out of 30,000? 3 of them were given by the same magistrate in Adelaide, so when she falls off the perch, it's one judge who's made a contested order for shared time. So base rate trap can lead to completely false information. Oh, if you go to court, you're more likely to get an equal time order because the judges are giving equal time orders. They're giving 4 out of 30,000 separating couples. Self-serving bias, this is great. This is called attributional distortion. And law school has a lot to answer for in this. At law school, we learn about blame, fault, breach of contract, tortious liability, contributory negligence. Who is to blame? Criminal liability, mens rea, actus reus, all that sort of stuff. So our brains are even more warped than ordinary human beings. Ordinary human beings have this problem. We have triple tracking. We find fault in other people. Okay, so this is called a self-serving bias here. You are stupid, but I'm having a bad day. So when I do something wrong, it's because of the environment. I'm under a lot of pressure. My child is sick. It's very difficult being a manager in modern Western industrialized countries. I blame the system, but if you have a problem, it's because you have a moral defect. The job of a mediator, just so you know, is one of our jobs as a mediator, is to reverse attributional distortion. Whenever someone says, oh, my manager's an idiot and I can't work with him because he went to the wrong school and he's basically got a personality disorder, our job is to reorient that by saying, so you're having difficulties working with Bill. So it is an environmental situation rather than Bill is an idiot. Next, ignoring other people's perceptions. Let's get down to business. Let's get down to brass tacks. Let's not beat around the bush. Our wiring is to do that. That's a mistake, a clear mistake, which will lead you into crazy outcomes and be seen as an incompetent negotiator. Let's not beat around the bush. Let's beat around it for quite a while. Let's find out what's important to other people. And then reactive devaluation, extremely important. I see this in mediations all the time. Who tends to carry offers in mediations? Lawyers. What does Psych 101 tell you? Never, never have good news coming from someone you dislike. Right? Good news, the right offer from the wrong person is the wrong offer. People react, they devalue offers or information from the wrong people. So Saddam Hussein said, I do not have weapons of mass destruction. Good luck. Wrong person to send the message. We needed a different message taker. So likewise with lawyers, we need to ask more often, who should carry our good message, our good offer, not necessarily the offer. All right, responses. Oh, this one's pretty good too. Yep, this is again Lunig. We'll leave the example for the moment. This one's even better. So this is the reverse of attributional distortion. While extortion, racketeering and murder may make you maybe bad acts, they don't make you a bad person. Responses to decision traps. Once again, most intelligent people don't think they suffer from this wiring. So here is what you can try. First, you structure a written analysis. What are the risks if we don't get a deal here? You create a document, one page. You use one decision trap against another. What are the risks if we don't get a decision here? And what are our goals, which are the reverse of risks? You find a wise elder. You find someone, sometimes called a court jester, you can bring into the negotiation, a friend, a wise accountant, a wise law partner, and they provide a new perspective. Those of you who like watching DVDs, can I recommend here you watch 13 Days, a wonderful DVD where the negotiations during the Cuban Missile Crisis between the Kennedys and their Russian compatriots are typified. And Kevin Costner plays the role of the wise elder, the court jester, who brings in hard statements which the Kennedys don't want to hear. So, conclusion, you must use some diagnostic categories. It's better than the black box theory. Ask why are we getting stuck here? Share your diagnosis with a colleague. Say, my initial thoughts are, we're making the mistake. Reactive devaluation, we're making the mistake. My client seems to have deep distress, verging on some sort of personality disorder. Share your diagnosis. Am I right? Am I missing something? And practice the toolbox of responses mentioned here. And if you can, is there one wrench in your toolbox you can use in many of these? That's bring a wise friend. But many of the people in these categories don't have friends, much less wise ones. So last cartoon. During the next stage of my development, Dad, I'll be drawing closer to my mother. I'll get back to you in my teens. So are there any questions coming out of that? Overwhelmed with information here. So this is the paper. I'll make sure that it's available on some kind of electronic system.